morning and welcome to the regular meeting of the City of Morgantown Board of Zoning Appeals. Thank you, everyone. Please turn off all cell phones or other devices that may disrupt these proceedings. It is the duty of this board to consider requests for relief from the requirements of the city's zoning regulations, to consider conditional use permit requests, and to hear administrative appeals. The board conducts business in the following order. We will review, amend, and approve minutes of a previous meeting. We'll move to unfinished business, take up new business, and then conclude with announcements from staff. Each request is heard in the order that it appears on the agenda for each conditional use and variance request. The following is done. We will introduce the agenda item, and the Planning Division will present a staff report, which may or may not offer a recommendation. The applicant agent will be asked to present their justification for the request, which may include questions by members of the board. We will then open a public hearing for each case to hear testimony in support of or in opposition to the request. Rules regarding public testimony are as follows. Anyone wishing to testify during the public hearing may do so once recognized by the chair, or may, in lieu of oral testimony, submit written testimony to the chair. All recognized speakers must approach the podium, state their name and address for the record, and speak clearly into the microphone. All comments must be addressed to the board, should be relevant to the application, and may not be of a personal nature or personal attacks. All speakers will be limited to 5 minutes. If members of the board have any questions of the speaker, that time will not be counted toward his/her total of 5 minutes. If there's a large number of speakers, including many who are part of groups or organizations, we may, to avoid repetitive comments, elect to ask for a representative to speak on behalf of the group. Speakers are notified that irrelevant comments or comments of a personal nature or personal attacks may result in the speaker forfeiting his/her opportunity to participate in the public hearing. We may elect to recognize the applicant agent at the end of the public hearing to provide rebuttal or additional comments, which will be limited to an additional 5 minutes. If members of the board have any questions of the applicant agent, again, that time will not be counted toward the total of 5 minutes. After all testimony is heard, we will declare the public hearing closed, and no further public comment will be permitted. Uncivil, unruly, or disruptive behavior at any time during this meeting is prohibited and will result in removal from the public meeting. State law requires the board to consider findings of fact for each conditional use and variance request. The request cannot be granted unless a majority of the quorum present finds in the positive of all of the findings of fact. The board may elect to continue the hearing to another date if it needs additional information or needs to deliberate further. Applicants and requesting parties will be notified in writing by the Planning Division of the board's findings and conclusions. Regardless of whether a request is approved or denied, decisions of the board can be appealed to the Circuit Court of Monongalia County within 30 days upon receipt of the written notification from planning. Any work done relating to decisions rendered by this board during this 30-day appeals period is at the sole financial risk of the applicant. Thank you for your consideration and respect for these proceedings and the opinions of all meeting participants. We're going to call to order Mr. DeWitt.
Present.
Mr. Misfeld.
Present.
Mr. Benison present. Ms. Cook is absent. We do have a quorum. We need to consider meeting minutes from the last regular meeting, July 16th, 2025. Any issues?
Nope.
Nope. I had a chance to review them. They looked good. I move that we accept the meeting minutes from the regular July 16th, 2025 meeting.
Seconded.
We have a motion to accept, seconded by Mr. Misfeld, to accept those meeting minutes. All those in favor? Aye?
Aye.
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 All right. Thank you very much. We have old business to consider. So this case is referenced as VAR 24-151 Brenda Hughes, 120 Doyle Street. Request by Brenda Hughes for variance relief from section 1331.08 of the city's planning and zoning code regarding accessory structures. City Tax District 14, 6th Ward, Tax Map 33, Parcel 34.5 in the R1A Single Family Residential District. Mr. Thompson.
Yep. In regards to VR 24-151, if you look at the screen, that's just kind of showing the parcel, as well as the kind of buffer for notices that went out. The parcel in reference is the center kind of green one. Following that are two images submitted by the applicant to support the location, some context of the topography of the site, as well as if you look into the packet, their third submitted document is more of a site plan showing the distance that they are suggesting to put this accessory structure from the property line. And this image, this is where it's going to be located. The plan for it based on that 20, I believe it was 26, but that distance set from the property line to show it there. The applicant seeks to move a shed at the above referenced address. The shed will be set 24 feet 6 inches back from the front property line. The applicant was in a legal case regarding this property previously, which is why it was tabled. This has been resolved at this time, as well as refer to the relevant sections of the code below in the packets. Additionally, in summary, the applicant wishes to construct an accessory shed structure in their front yard. The applicant is requesting variance relief regarding allowing an accessory structure in the front of their property.
And the front setback is 20 feet, right?
There isn't any for an accessory structure, but there isn't one. This would just be allowing it in the front
In the
yard.
front
Yes.
Of the
Yep.
primary, right.
Is that the structure? They want to move that? Okay.
Well, that's where it was moved to. If previously it was located closer and a little bit onto the neighbor's property, and they've since, after that legal dispute, have moved it to closer into the property.
Away from the property line.
Mm-hmm.
Yep, okay. All right.
To where it's proposed to go?
Yes, there's no permits or anything at this time.
So it's already there.
Yes.
So what happened with the case then?
She would be able to
The
speak
applicant
more
can
to
speak to
that. Yeah. Yep.
Right.
Okay.
Thank you, Mr. Thompson.
Yep.
When we do have a representative for this case, clearly, would you like to approach and again, state your name and address for the record?
I'm Brenda Hughes. My address is 120 Boyle Street, Morgantown. Just to explain the pictures a little bit. The first one is where it was,
Right.
which it was a little bit on the neighbor's property, and they kept opposing us to break the variance.
Right.
That is where the court ordered me. They told me I had to move it.
Right.
So we moved it, so it is now clearly way off of the property, the neighbor's property.
Yep.
So the second picture shows you where it was moved.
Right.
So it's clearly off the property.
Right.
So that's where the two pictures are.
Mhm. All right.
And in case you have forgotten, months that I've been here, there was no way to put it in the backyard, no way to put it in the side yards, because the side yards, if I put them in the side yards, they were too close to the neighbor's property.
What, and you had topographic
Yes, and I had pictures to show you that in the past.
challenges.
Yes.
Right.
Yes, that's one of the side yards.
Mhm.
And that's why we couldn't go through the other side yard, because it was too
Right.
narrow.
Right.
And they are actually my only neighbors. So they're the only neighbors that actually see that shed.
Right.
You can't see it from the road.
No. Only in the wintertime.
Yeah.
You can sit at Kroger and you can look up and see it.
Mhm. And it's wooded on the other
Yes.
three.
So remind us, what was pending in that civil case last time?
They had filed a lawsuit because of the property and because of many other things, which that is still in court. We are still waiting on court date. However, there was a semi-court date on May the 15th, and the judge did say that she would allow the structure to be moved. So she did say that the structure could be moved. So
So it wasn't even, yeah.
yeah.
She ordered it to be moved
Ordered it to be moved, yes.
to where it's proposed to go here?
She did not specify where it was to be moved, she just ordered it to be moved off of the neighbor's property.
Right.
Okay. But that was just like a injunction that that case is still pending?
The other case, things are still pending, yes.
So there's two?
They don't involve the building,
Well, there's many different things with the neighbors that's still pending, yes.
but not around the building, though, something else.
Not with the
Okay.
building, no.
So it sounds to me as if we,
But will it bear on this issue
On the
specifically?
building? No,
Because she's already ordered it off the property line,
yes,
and it's already off the property line.
yes,
Whether or not we approve or deny this, it's still going to be off the property line.
yes.
right.
Ultimately, if
The
it,
building is not an issue now, because it's off
Yeah.
of their property.
right,
So that part has nothing to do with
And
it.
you just need us to say it's okay to sit where it's at.
In the front yard.
Yeah.
So with regard to granting the variance or not, so I can see two options. I can see the accessory structure remains where it is, or it's removed entirely.
yeah. And
So to cover the first contingency, I think, because the case has been, with respect to the accessory structure, it's been adjudicated, I think it's appropriate for us to grant the variance.
Well, yeah, because the judge isn't going to order it to be removed.
No.
It's off the property line. That's all they
She just
can.
wanted it off their property.
Yeah.
line.
Yeah, that would be a city issue. If it's not approved, then she'll still need to apply for a permit after this.
Yeah, to get a permit.
Yeah, and if the variance isn't approved, then it would have to be removed, because
Right.
it wasn't built with a permit. So that would be that other
It's been
scenario.
That's before I could apply for the permit,
Yep.
because of the way everything was done.
It looked like it came pre-assembled.
And as far as that driveway, so you have an easement for that driveway? Did you get it from the previous property owner?
What had happened, my house is 26 years old, and the first house, their house was built first, which they are the secondary owner. The people that lived in that house first has since passed. So they are the secondary owner. We had the agreement with the first owner. So when they bought the house, I guess they took over that easement
Right.
thing.
Runs with the
I have
land.
lifetime rights to it,
Right.
and I'm the only owner of that house so far.
Okay. So that driveway and your easement pre-existed there?
Yeah. It's been there since, of course, I lived there.
Yeah. So that's my one hiccup with this, which is my same hiccup with most of these variances, is whether the particular aspect of the property that is requiring the variance is due to the property itself or due to an act of the owner, right? So the driveway was where it was when you bought that property, right? And it was facing that street when you bought it. So the problem since then is really, it's due to the property dispute with the owners,
Yeah, because it was like, I don't know.
or with your neighbors, sorry, not your own, not the owners.
Yeah, it was a couple inches on their property, which I assumed was my property.
Yeah.
When it was put there.
But that actually is irrelevant, because whether it was your property or theirs, it doesn't matter, it's off the property line.
Right.
So like, they can't have it removed where it is now, it's on your property.
Definitely not the property now.
But it's.
But you couldn't have put this shed there before your neighbors moved into that house.
No. No, it was after they had moved in.
Right, but I'm saying if you had, that was still the front of your house, that side of the house. So you couldn't have put that structure there even if your neighbors didn't have an issue with it.
Well, I don't guess.
Right, but I guess what my point is that the issue is, to me is that like
Is there a
her
hardship?
problem isn't really due to the property itself, it's due to which way you had your house.
Oh, well, my house
Oriented,
has been there for
basically.
26 years, I mean,
Right.
and their house has been there for 27.
And if putting the accessory constitutes a reasonable development of the property, in terms of placement, there's nowhere, regardless of the easement or the driveway, there's nowhere else to site the accessory structure. So I guess the other question is, what, if you don't opt to retain the accessory structure, what's the hardship?
What's the way?
What's the compelling reason for following through with this accessory structure, regardless of where it's sited on your property?
Well, my husband uses it as a music studio. So that's why we purchased it.
Right,
We purchased it like 5 years ago,
right.
and we just now, like 2 years ago, had an issue with it, with them.
Okay.
So it sat there for 3 years without an issue.
But it had been placed there without getting a variance in the first place.
Yeah, because I wasn't aware that something that was already built had to have one.
Okay.
And also, there's also the issue of. maybe
But because of the
a-
contours of the property itself, you can't put it anywhere else. Yeah. So I mean, it is all there.
And it's off the property line.
And what's the issue with where it's at now versus like, I mean, could you snug it up against the house on one side? Is that a possibility?
No. Because you have to be so far from the property lines.
Well, I mean, that's a variance request as well.
Okay.
You know, But,
Yeah, that is the other, like, she could just get a variance for the other side of the house.
yeah.
But there's no.
But I thought it
way
couldn't
on
be-
each side of the house.
Right, like physically you can't put it there. Yeah,
Physically,
okay.
you can't because of the topography.
Property lines, you'd have to cross property lines to get it over
And the
there.
property lines, too.
Well, the other side of the house is wooded. There's no way to get to the one side of the house.
But like right in front of the truck right there on in that image, like could it not abut against the side of the house right there?
Well, see, right there where that tree is,
Mm-hmm.
that is their property line.
Right.
Oh.
Like, this,
But-
this bush right there, that is exactly their property line.
Right.
So that's not enough space.
But if it's snugged against the house, would it give like a, is that 10 feet from the property line? You'd
I don't
need,
know,
you get
because
ready
then I have a
variance.
gas meter there,
Oh, yeah.
so I don't know
It's
if it
creating more
would fit.
difficulties. I mean, it just looks like it stands out kind of oddly where it's currently positioned in the front of the house.
Actually, it really doesn't.
It does, that works for you? Okay.
Yeah, because we have a parking area right there, and it really doesn't,
Okay.
because we park in front of that. Yeah, right there in front of it, and it's really been working.
Okay. Does any of this revolve around like noise complaints from it being a music studio? Okay. And what's the city say about it? No problem.
I mean, yes, as far as any comment from the city, it was a structure that was brought there without a permit, and then once it was made aware of that, then we reached out and followed through this kind of where it is now, of, if you'd like to maintain it in the front, we'll work with you if you can get the variance, but otherwise you'll have to have it removed because it's a non-permitted structure, and it was put there without city knowledge, so, yep.
I guess
It's not visible from the road, so I mean, that was kind of.
another way to reframe this is, regardless of the permit, would we reasonably grant this variance for this accessory structure in someone's front yard?
I mean, she's
I
in a
guess-
wooded area. She's-
I would say, I mean,
And
arguably,
apart from, like, it being adjudicated in this, like, remove all of that, does this constitute for you in your mind, is that, I mean,
Yeah, because you can't cite it anywhere on
And it's,
any other
I mean,
side.
it's reasonably developing the property within her or anyone else's property rights. It's not an unreasonable, and we can't really anticipate going forward what is going to play out in circuit court, but I guess just if we take out all the
Well, I
variables
don't think it actually matters.
and just consider it, does this constitute a reasonable development of her property given the topographic challenges?
I think I would,
Yeah, I think it's actually an easier yes for me.
Yeah.
I think the court,
Put it in
all the other stuff is kind of like a red herring. It doesn't, I don't think that stuff actually matters,
Right.
based on what I've heard.
yeah.
Because really, this is just about, she can't put it physically on any other side.
Anywhere
I
else.
applied for a similar variance years ago. Put a building right against my neighbor's property and needed a 5-foot variance, so.
Yeah.
Because if it weren't this, the music studio would be, oh, I want to put a one-stall, you know,
Something
for my
that's
vehicle
yeah.
or my tractor.
Mhm.
And that's where, you know,
We approve those all the time. Or not all the time. I know.
Yeah, the really only, close factor to me is the first one, whether it's going to adversely affect, adjoining property owners, because they
For me,
obviously do have a problem.
for me, a kind of a complication because, all right, it's not a garage, but I still need the drive to access this, to make use of it. For me, a complicating factor, it's their driveway, but there's an easement. That's kind of, for me, that's kind of a complication.
Yeah, that easement is very strange. So how much of that driveway is the easement right there, like?
Oh, that's all my driveway.
Oh, okay. It's just, you're not.
Yeah, I mean, that's not going to
And
change.
that's my parking area.
They can't keep her from using that.
Yeah,
Yeah.
that's all my parking
Okay.
area.
And if there was any objection from the neighbor, they would be here.
Yeah, definitely. They
And there's no,
wouldn't
we
live here.
do want to note, there's no additional correspondence.
Yeah, there was a,
Yeah, I mean, having an adjoining accessory structure is a reasonable use of someone's land. I think most people expect that they should be able to have a shed. So,
Right.
no problem there. She can't really put it anywhere else physically.
Is there, there is a condition for this? The standard
Yeah.
condition? Can you
Yeah,
just read that into the record before we take up findings of fact?
Yep, please see the attached application to review the findings of fact listed, as staff have had no comments or modifications. This attachment can be found below the conditions. Staff have no objections to the applicant's request for variance relief. If the Board of Zoning Appeals grants the applicant variance relief in regard to Section 133108 of the city's Planning and Zoning Code, the accessory structure shall be subject to the following conditions, which is, any other modifications or changes to the site plan shall be compliant with the city's Planning and Zoning Code, or the applicant shall seek variance relief from the Board of Zoning Appeals. And then that's all relevant conditions to this.
Okay. Thank you. We're going to open, for the record, we're going to open the, did you want to add anything? Okay. We're going to open the public hearing to take up that point, and then we'll move to, all right. We are going to go ahead and open the public hearing for VAR 24-151. Anyone else wishing to speak in support of or in opposition in this case, now's your opportunity to do so. Seeing no one, we're going to close the public hearing.
Well, they've given up too.
Right. Further discussion or questions regarding findings of fact? I mean, they're pretty straightforward.
I mean, I think we should approve it, but I think, so, the third finding of fact.
Right,
The
that's-
unnecessary hardship, that needs to address, the physical contours of the property are such that it can't be cited on any other side.
Right, we can add that. Can we add that?
I mean, that's the hardship.
Yeah,
Third
you
finding
can
of fact.
amend it, you can add to it, it's up to you guys. So-
I'd like to put that in. Well, I mean, the other hardship is they've recited their accessory structure in answer to a court order. In my book, that's another additional constraint that that the applicant is having to work within. So there's the court order, they've moved their accessory structure to a location that takes into account topographic challenges that the property presents. So they're moving it to the exact location off a property, the property line, to give relief to the neighbor, but they're also moving it to a location that takes into account topographic challenges that the property presents to the applicant. So can we put all that in there too?
What exactly would you like me to write in?
We are granting the variance in recognition of the fact that the applicant has to site the accessory structure in a location that takes into account topographic challenges and is answerable to the conditions of the court order.
And they already have so much sunk cost in this already.
And we're granting the variance also because what the applicant is proposing represents a reasonable development of their property under commonly recognized property rights. All right, so any other discussion on finding of fact?
A motion to accept the finding of facts? Oh, wait.
I'll read it back and see if that's
Yeah, go ahead.
sufficient with you guys.
That's fine.
So the addition will be, the variance will be, in regards to question 3, granted in recognition that the applicant has to site the structure in a location considering topography and a court order, as well as a reasonable development of the property.
Yeah,
Cool.
Motion we accept the finding of facts?
and I second that.
As amended.
As amended, yep, with regard to the third finding of fact referenced in the packet. So we have a motion to accept the findings of fact with a second. How do we vote?
Aye.
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 So we've accepted the findings of fact for VAR 24-151. I move to grant the requested variance, allowing an accessory structure in the front yard. For this case, do we have a second?
I'll second that.
So we have a motion to grant the variance requested for VAR 24-151 with a second. How do we vote?
Aye.
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 Okay. We've granted your request for a variance. Keep in mind, so you'll receive written notification from planning typically within a week, but keep in mind that it can be
It's already been done.
appealed to the circuit court, as you're very much aware, Circuit Court of Montague County, and then any work that you undertake in that 30-day appeals window, you do your sole financial risk. Thank you very much. Thanks for coming down this evening. All right, so new business, VAR 25-061, City Neon, 228 Prospect Street, request by City Neon for variance relief from section 1369.08 of the city's planning and zoning code regarding lighting and design standards, City Tax District 13, Second Ward, Tax Map 26, Parcel 126 in the B1 Neighborhood Business District.
So in regards to variance 25061, in the package as well as on the screen, I was just going to show you where that property is located as well as that buffer zone as previously mentioned. Then on to the next attachment, shows the actual kind of design, the location, the size of the sign. If you'll refer to the top there, you can see the measurements, and it will be located here.
When is the city packet going to be updated with like new provisions for signage?
Soon,
Okay.
hopefully. The applicant wishes to install one internally illuminated channel letter set for exterior signage at the reference address. The applicant wishes for one 18-inch by 132 5/8 inch wall sign showing the name of their business. Related sections of the code can be found below. In summary, the applicant wishes to install an internally illuminated wall sign at the reference address above. The applicant is requesting variance regarding internal illumination standards within the B1 district. I'll go through and I'll just also read the conditions and the rest of it now. Please see the attached application to review the findings of fact listed, as staff have had no comments or modifications. This attachment can be found below in conditions. Staff have no objections to the applicant's request for variance relief. If the Board of Zoning Appeals grants the applicant variance relief from Section 133108 of the city's Planning and Zoning Code, the accessory structure shall be, that's not the right code quote, but it's still for the sign. Any other modifications or changes to the site plan shall be compliant with the city's Planning and Zoning Code, or the applicant shall seek variance relief from the Board of Zoning Appeals. And then that concludes staff report.
Thank you very much. Do we have a representative for this case? Hello.
Ian Smith, sitting on 1095 Chapel Road, Morgantown. And, hopefully cut and dry. Obviously, you guys have seen, City Neon signings throughout the time. It's a 63-year-old company. It's, in this particular case, we're just a couple of doors down where we did the 304 canteen sign that we were here for as well for that variance.
Right.
Everything that we do utilize from our materials are high quality, industry standard. In the case of this particular matter with illumination, we are a UL certified facility. So as far as all of the electronics and things like that go, we have strict guidelines that we have to follow for the means and methods of which we do.
So it's for it's materials and illumination. Is it on, can you speak to like business hours of operation? Is the illumination going to be on a timer, or is it just going to be?
Correct. So there's two methods for which the illumination would take place. One, we could put it on a timer, or two, we could put it on what's called a photo cell. Really depends on the sunrise, sunset of that. If you have too much shading, then the photo cell is not the ideal way to go. You can put it on a timer, but
right.
We'll obviously work with the client for what makes sense and what we have to work with to do that.
But they're thinking about just 24/7 for wayfinding and just for
We
to
absolutely
promote the
could.
business.
Yes, the sign. It's. We would work with what the client wanted, assuming that we're not violating any of your guys' codes as far as restrictions of illumination during daylight. But yes, you can.
Do we have any of those?
I don't think so.
I don't think
Can
we
you
do.
speak to that?
What specifically?
Like illumination hours or luminance values, like in an area?
Not really. We don't really have anything that kind of level, for at least like a
We really
wall
can't tell
sign.
them to put it on a dimmer or a timer then?
Not at this time, no.
I can speak to the fact,
Oh, you have
the
to-
lights will not be on when we're not.
Yeah, can you just state your name and if you're,
Jeffrey Bailey, 116 Legacy Drive in Morgantown. We're the owner of the place. You actually wouldn't even recognize it now since we've redone the outside
Right.
and all that. So, but anyway, and now commercial doors. But the lights will not be on when we're not in business.
Oh, really?
That's good.
We will turn them off, just like we do the canteen signs.
Oh, right.
We turn them off the moment that we close. So they
Oh,
will
right.
not be on in the wee hours of the night.
all
I
right,
like that.
yeah.
But either
All
way,
right.
we can't really tell them what to do. so.
No. It just, all right, anything further you'd like to add, or? No?
think so.
Okay, thank you very much.
Thank you.
Appreciate it.
It's pretty straightforward.
Yeah, I think it's pretty cut and dry. I think we just, we're responding to legacy rules right here for materials and lighting, so
Yep.
I think we just follow suit with what we've done before.
Any issues with any of the findings of fact? All right, so I'm going to move that we accept the findings of fact.
I'll second that.
Public hearing.
I'm sorry.
Yep.
Oh,
Yeah, we need to do public hearing, I'm sorry. So, I apologize. Anyone wishing to speak in support of or in opposition to this case, VAR 25-, 061, City Neon, 228 Prospect Street. Now's your opportunity to do so. Seeing no one, close the public hearing. Okay, now we can go with the motion. So I move to accept the findings of fact for VAR 25-061.
Seconded.
Right. So we have a motion to accept findings of fact, seconded by Mr. Misfelt. How do we vote?
Aye.
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 And I move to, this is a very straightforward case. I move to grant the variance request for VAR 25-061, 228 Prospect Street.
I have a question that's kind of not related to this part, but is there any issue with WVU with the coloring and stuff? Like, okay, good. Because they like to get their hands in it.
WVU has a trademark on their specific colors.
Yeah.
When we did this actually for the canteen.
Yeah.
And now for the market, we made sure that we were not
question.
their exactly. You have to alter from their Pantone color,
Yeah,
I
yeah.
think that's what it's called.
Yeah.
And that's what City Neon's very good at doing, to make sure that there's no
I
copyright.
just kind of want to make sure you would have to take that down in a couple years, because
Yes.
they're
It's a very exact science with these
Cool.
guys.
We're delicate to that. We do a lot with them, and there's
Yeah.
audits and the whole collegiate licensing and everything like that. Like, yeah, we're
awesome. You're well aware of that issue.
we're guarded for that.
Cool.
Yes.
Good question. All right, so we have a motion,
I'll second that.
seconded. There is a condition, which Mr. Thompson has read into the record. So how do we vote?
Aye.
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 All right, so we have granted your request for your variance. You will receive written notification, 7 to 10 business days. It can be appealed in the Circuit Court of Monongalia County. And just keep in mind, any work that you undertake in that 30-day appeals window, you do at your sole financial risk. Thank you very much. Good luck with your project. All right. Next case is VAR 25-063, Michael Pompili, 367, 369 Maple Ave, request by Michael Pompili for variance relief from section 1331.08 of the city's planning and zoning code regarding accessory structures, City Tax District 10, 6th Ward, tax map 36, parcel 387 in the R1A Single Family Residential District. Mr. Thompson?
In reference to variance 25063, as with the ones coming before, this is just kind of showing the parcels in reference as well as that buffer zone for notification. Then going into it is a picture of the site taken off Google Images showing the accessory structure there, directly in the center. The applicant wishes to combine lots at the above referenced address. There are 2 structures that would exist on this new combined parcel. The building on the rear parcel would become an accessory structure, a storage/garage for the main dwelling on the street. Both buildings are pre-existing, and the accessory structure will not be a dwelling unit. The rear structure is above the height requirements for an accessory structure if it was built today, and then related sections of the code can be found below. In summary, the applicant wishes to combine neighboring lots with structures on them. The applicant is requesting variance regarding 2 feet of height for an accessory structure. See the attached application to review findings of fact as listed. Staff have had no comments or modifications. This attachment can be found below. Staff have no objections to the applicant's request for their variance relief. If the Board of Zoning Appeals was to grant the applicant variance relief from Section 1331.08 of the city's planning and zoning code, this accessory structure shall be subject to the following conditions. Any other modifications or changes to the site plan shall be compliant with the city's planning and zoning code, or the applicant shall seek variance relief from the Board of Zoning Appeals.
So the accessory structure is a house?
The applicant can speak a little bit more to it, but previously, there are 2 separate parcels, and that was a individual structure there. So if you'd like to speak just a little bit more, he'd know the history of it.
81 pumpkin, unlimited days. The other side of it has the garage door on it. So,
To the right
yeah.
of the
yeah,
photo?
The right side of it. is the garage.
Because Maple's to the right,
Yeah, Maple's above,
right?
so, but it's, when I purchased it, that's what it was. It was always just a garage
Yep.
and a storage shed.
So where is the storage shed?
Well, it's, the garage was in the bottom, the top was the workshop, like
Gotcha.
area. So on the side, you know
So,
what I mean? It's-
oh, so so we're defining like a house as as an accessory structure is what we're trying to do, is that correct? It's just a little too tall?
Yeah, like previously,
Yeah.
it
It's
would,
already done.
It's never been a house.
Oh, okay.
Nobody's ever lived in it.
I guess I'm having a hard time. Can you point to which that on there, what I'm looking
The
at?
only
as
thing
accessory
I can
structure?
say is it was probably like a carriage house and service quarter one.
Right.
Oh,
But there's
okay.
never been an occupancy on it.
It's interesting, though, that the lot, that someone went to the trouble of,
Parsing it out.
yeah.
it seemed like maybe,
It was in the original, the original divisions of them.
Yeah.
Was in the original South Park subdivision.
Okay. And it's got a porch and everything. It's interesting.
On the rear, yeah.
And we're just trying to classify.
So is the variance a condition to getting the lot combined, or the parcels combined?
Yes.
Okay.
You just want to combine, like for.
But like, they didn't already, are they already combined?
I believe it went, no, so they're two separate now, but the planning commission, we're fine with it, but with the exception of this.
You know what, because they give me the list of the stuff you gotta do, you know, survey, new deeds, all that.
Mm-hmm.
And one of them is when they get it on Google, the roof's 2 feet too high.
Oh,
Right.
Yep.
So primarily, it's the accessory structure,
Well, I mean,
height.
if this was a new construction, we could start with that.
Yeah.
Yeah.
I mean, it's been there since 1920.
Yeah.
And we ain't really changing any of the demographics of the area.
Yeah.
You know, it's what it has been since 1920.
I mean, is there already plan to doesn't even matter, finish the sides, refinish area, is it just gonna leave it as is, or what's?
Yeah, it's just gonna stay
Okay.
what it is. you know.
Because another possible scenario, you could separate, if they separated out the parcels, would they meet minimum lot requirements or no? Like if you went back to two
Yeah, I was gonna
principal
say, so
structures,
what is that property on the other parcel then now?
that's the
considered?
principal structure.
Okay, but there's nothing else on that other parcel?
No,
Yeah,
that
well, there's
house.
3 parcels there.
yeah.
Oh.
I'm just thinking if you went back to, and you separated out the lots again, and you went with 2 principal, or 2 primary, then the maximum, the 18-foot, that wouldn't even be an issue any longer. I don't really.
Yeah, if it was to be like, yeah.
This seems pretty
Even
cut
if
and dry.
if it stayed just a parcel.
Yeah.
Yeah, right. And just, you could have two principal
But under
structures.
the new,
And
the
then,
new codes, that sitting on its own parcel ain't allowed.
Oh.
It'd have to be a principal use, like a dwelling
that's what
or,
I'm saying.
That's what I'm saying, is like-
If it were a principal structure, then the roof,
Yeah.
that would need, it would be a moot point.
It doesn't
That's what
even
I'm
work as
driving
a
at.
separate
Never been a
parcel.
principal
But
structure.
it can't, they won't give me the occupancies on it. Like, I can't rehab that building and make it a house.
Why not?
Because there's not enough parking in the area.
It's the parking, it's not the minimum, it's not
Parking
even
always gets to
minimum
be
lot.
weird, doesn't it?
Yeah. Because that was one road and this was the other.
Because it is one
There's no
one
other
driveway.
parking area.
There's no, and the street you can see here.
It's
is
narrow,
long,
yeah.
And there's no street parking.
No.
No, there isn't. There's maybe one space out front.
Yeah, clean the top.
In the ditch.
But this section here is right behind. Second Ward, the old Second Ward schools
Is
a
it?
couple houses down.
Oh, that's right, yeah, that's right. Yeah. I don't,
How old is that?
1920s?
Is what they're estimating.
It's about when my house was built.
Yeah.
Huh.
And some of the height, I mean, that's kind of having to construct the foundation in a certain way.
Oh, there's no
because
way
of
to change that.
Topographic variability.
Yeah, no, it's just-
That's what's driving the
Oh, yeah, where are they
relative
citing
height
it
of
from, the
height.
low side or the high side? What's the, I'm just
They
curious.
did it from the top.
They did.
Where because technically they're coming, the garage door's not the front of the structure.
Gotcha.
So that's where they shoot the height from.
Gotcha.
Yeah, I don't,
I mean,
it meets all the setbacks as far as that went for variance. As far
So we're just the
as-
height, you're not blocking anybody's view,
And it's-
there's nothing
right,
going on.
and it's not as if. the-
What
the ma-
else is it gonna be? It's like, this is the only thing that fits.
And it's not as if the roof line of the accessory is higher than the roof line of the primary.
No, no, in fact, they look like they're not even
that.
playing with each other.
The other house is up, you know what I mean? It's up on Maple.
And it's not out of proportion with like the neighbors.
And the aesthetic is already there, I mean, I'm fine with it.
Yeah.
There's nothing we can do, I mean, or he could do, other than shave off the roof. It's probably balloon framed or something.
Yeah, I mean.
You can't
and
really
they-
touch it.
They 2 feet off of it.
You can't do
That's
that.
the whole-
Yeah, you can't do that. It's all held together by the,
No, and the structure's still sound, you know what I mean, so there's nothing with that.
it's probably built with nominal 2x4s and 2x6s, yeah.
You know.
All right.
Anything further to add? Thank you very much.
Yeah, thank you. Thanks.
Thank you very much. So there, can we just, we'll open the public hearing, but let's go state it's just the standard condition?
Yeah, just the standard condition as is was the other two.
Okay. So we're going to go ahead and open public hearing for VAR 25-063, Michael Pompili, 367, 369 Maple Avenue. Anyone wishing to speak in support of or in opposition to this case, please do so now. Seeing no one, we're going to close the public hearing. The findings of fact are pretty straightforward. I'm going to move that we accept the findings of fact for this case.
Seconded.
VAR 25-063. We have a motion to accept findings of fact, seconded by Mr. Misfeld. How do we vote?
Aye.
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 And I move to grant the variance for the roof, maximum roof issue for this case. Do we have a second?
I'll second that.
So we have a motion to grant the variance request to exceed the maximum height allowance for the accessory structure for VAR 25-063. We have a second. How do we vote?
Aye.
Aye. Aye. So we have granted you requested variance. You will receive written notification from planning, 7 to 10 business days. It can be appealed to the Circuit Court of Monongalia County, and any work that you do in that 30-day appeals window, you do at your sole financial risk. Well, thank you very much.
Thank you.
Have a good evening. We're moving to VAR 25-068, Robert C. Burns, 844 Riverview Drive. Request by Robert C. Burns for variance relief from section 1333.03 of the city's planning and zoning code regarding minimum lot provisions. City Tax District 15 in the 4th Ward, tax map 015, parcel 21 in the R1 Single Family Residential District.
As with the previous cases, here's a show of that referenced property as well as the distance for notification. Then after that, it goes into the survey kind of showing the plat of the property in reference, and this will also be connected to the next variance, but this is the property in question for this one, and they are wishing to acquire this portion of the neighboring property, and that is making this one kind of whole property here shaped like that. The applicant wishes to acquire a portion of the neighboring lot at the referenced address. 844 Riverview's driveway is on and accessed through 888 Riverview for some period of time through a civil agreement, being this is that driveway. They are now interested in changing the parcels, so an agreement is no longer necessary, and it would just be by right. This change would add lot size to 844 while decreasing the lot size of 888. Refer to the relevant sections of code below. In summary, the applicant wishes to combine neighboring lots with structures on them. The applicant is requesting variance regarding 2,100 square feet of minimum lot size. Please see the attached application to review the findings of fact listed, as staff have had no comments or modifications. Staff have no objections to this request for variance relief. If the Board of Zoning Appeals grants the applicant variance relief from Section 133303 of the city's Planning and Zoning Code, the new lot shall be subject to the following conditions, being the standard condition as similar on the other variances, being any other modification or changes to the site plan shall be compliant with the city's Planning and Zoning Code, or the applicant shall seek variance relief from the Board of Zoning Appeals.
So how much are they missing? I see 2,100 square feet minimum lot size, and I see 7,200 square feet minimum lot size.
Yeah, so they are getting, the lot will have afterwards 551. It'll be 5,100, so this plus this.
It was already too little.
Yep,
So they're
So
going to
we're
be,
just increasing it and still being too little?
yep.
Oh.
so they're still going to be 2,100.
Under, yep.
Square.
Yes, currently it's, I'm not sure what, exactly off the top of my head what it is now, but it's small, it's smaller than what is permitted already. Even with this increase of the driveway,
Yeah.
they're still under by
Right,
2,100.
so this is kind of silly. I mean, in a way, it's like, they're already under.
This property though is going under the amount.
The other one's going under too, so they're.
That one
See, that
was,
Was the question that I wanted to ask, is that going to negatively impact?
this was size-wise compliant. Then removing this makes it slightly under. So that is where,
So it goes to maybe 6,800?
So is there another driveway?
I think it's 7,100. It's only a variance of about
So are
100
there
or
not two
so.
variance requests here, or there are two, this is part of?
That's the next one.
Oh, so
Yep.
this is, when we answer this one, we're effectively answering the other one.
Yeah, but they're different parcels, different
I
owners.
see. And they're both here. Yeah,
Well,
okay.
Well,
So this is just a driveway?
correct. Right now, this is how they access this property.
Is
through
it
here.
shared, or is there a separate driveway for that?
He could speak more to it, but it's just theirs. Like, this is their driveway that they've had an agreement
Yeah,
through.
if you go with the, all the encumbrances on the easements
then you-
for use and maintenance and liability,
Yeah,
this
it
is,
just drags out, so it's going to be bad later.
The easement's been in effect for 85 years.
85 years, that's cool.
Yeah.
Yeah.
These lots were subdivided in 1940 or 19...
I live on a lot that's too small too, so,
Yeah, they were already on the
yeah,
lot.
I live on a half
They were
lot.
the ones who built lots.
So you're gonna be taking the driveway. Are they gonna maintain, are they still gonna have an easement for that driveway then?
No.
no, they won't.
They're just giving it to them.
When this was all owned together in the 40s,
Mm-hmm.
Judge Baker sold this lot to this, whoever owned it then, obviously this guy in the 40s.
Yep,
And he gave them an easement here for the driveway.
right.
Okay.
Mr. and Mrs. Caruso died, their daughter lived in the house for the last 20-some years, the ADVA, she just died. The sister, the
And
other
there's a
daughter,
surviving daughter who lives somewhere
she
else.
lives in Massachusetts or Connecticut or something, and Camille wants to sell the house, and we got looking at it, and Bob Burns looked at it too, and he said, I'd like to own that, and I told them both, I said, you're gonna have a hard time selling this, because there's no allocation of
Protection,
liability.
yeah.
There's no maintenance, right, I mean, it's a simple 3 sentences in a 1940 deed.
Wow.
Yeah,
And topographically, it's actually separated. It's downhill. there's
Oh, so
shrub.
that's a
So what it does,
bank.
if you go to the aerial, it looks like it's a separate yard.
Gotcha.
right.
Interesting.
And does 888 have a driveway on the opposite
They
side?
don't have driveway at all.
Yeah.
So what,
Do they need, we don't need one though.
what are
They
the,
don't need one, they never had one.
Yeah,
oh, all right, so just on, okay.
you just pull in.
He wouldn't have a driveway on the other side, except for the fact that they created one in the 1940s so they could drive their, most horse and buggy back in.
Yeah, yeah.
Could you also state your name and address?
Robert what?
Thank you.
But the neighbor's still gonna have adequate parking and everything.
They're not changing the use or anything, so it won't, it's looked at non-conforming pre-existing for parking.
Okay.
Because they're not changing the use or,
Minor subdivision, subject to, because we're gonna make the Caruso lot smaller, and it's now going to be non-conforming
Yeah.
lot size, go get a BZA approved this.
Yeah.
and we'll-
I mean, it's
It
already,
looks as if
it's already in the deed.
the other property, whatever, I don't know what the compass points are, but to the left it looks as if the other properties have minimum lot challenges too.
Yeah,
Everybody's got-
there's some also, yeah, in that area, it's not uncommon.
All land is non-conforming
I-
to lot size.
My-
Well, that sets precedence as well.
My initial reaction to this was, why not write it, keep things as they are and write something,
You can't sell it, it's hard to sell.
right,
Because it's going to tie our hands stop.
Yeah.
right, just write it to the provisions bearing on the easement, but I think this, what's being proposed is the best solution.
I think so too, yeah. I hate easements in that regard. I think they're a pain in the ass.
That's what planning came up with, especially with Tim and Pete being lawyers on planning.
Yeah, that's why.
Yep, all right.
Cool.
Anything additional to add?
Unless you have questions.
We may, but not at this time.
Good.
Can you do them both at the same time, Sam?
We could, well, I say we'll go through the public hearing, and then we can go to the next one, and they can vote at the same time, but, yep.
That's probably a good idea, I think.
In lieu of having you kind of come up again.
And we'll do the public hearing for each individual case,
Correct.
Okay.
Yeah.
if that's all right with you. And then we'll describe.
You know, that's pretty bad, because so a judge gave that easement and only gave it,
Back.
put 2 sentences. He didn't write a very good easement.
Back in the 40s, it was just a handshake.
I tell you, the party 80% of the lawyers in this town would still do it 85 years later.
And-
Oh, yeah, they would.
and just out of curiosity, so the easement verbiage, is that, it's referenced in both deeds?
It's
It's in the deed.
1940 deeds, but it carries through.
Yeah, you can't change.
You don't have to repeat it. I think it's in some of the deeds coming through the chains, but it doesn't matter. Once it's created, it's always created. It doesn't
Yeah.
go away just because you don't repeat it in the next deed.
Right.
Okay.
All right. All right, so we are going to, there are separate cases, we're going to open the public hearing bearing on VAR 25-068 Robert T. Burns, 844 Riverview Drive. Anyone wishing to speak in support of or in opposition to this specific variance case, please do so now. Seeing no one, anyone? No? We're going to close the public hearing for this case. So, well, can we, I guess we should do, so the findings, let's just do them separately. Findings of fact for VAR 25-068. Well, we have correspondence bearing on this case. Are there specific findings of fact for, I don't see them.
The findings of fact is that document you're talking about, this, the one here, that is the findings of fact. So the first paragraph is 1, then 2, then 3, then 4.
Right, okay. We're not going to read the correspondence into the record.
No, that's just findings of, yeah, it'll be recorded as a part of the findings of fact.
Does anyone want to speak specifically in response to the letter submitted by Robert C. Burns? And the referenced address is the 844 Riverview Drive. Commenting at length with regard to the easement and the driveways.
No, I think all the elements of a
I-
variance are there.
So I think this is, and so we're granting the specific variance for, can you speak, Mr. Thompson, specifically to the nitty-gritty, the variance we're granting specifically with regard to 844?
Okay, so the variance that you would be granting, if you do approve it, would be for the parcel, that property 844, the lot size of 2,100 square feet. And that's it, not for setbacks, anything additional, just the size of the lot being under the allowed amount at 2,100.
Square foot.
Yep, and for as long as this kind of parcel exists in the way that it does, then that can be maintained, and if they were to, put a building or something else in there in the future, it wouldn't be an issue, if other, requirements are met. This would just be saying, for this parcel, this property, it is looked at as a variance for its size.
Okay, so with regard to 844 Riverview Drive, we are granting a variance that will waive the minimum lot size requirement.
Down to the 5,100.
5,100 from 7,200 square feet. Okay,
Except it's never been 72.
Right.
Yeah, it's actually getting bigger.
It's getting bigger.
right.
Yes.
You're decreasing the degree of nonconformity in looking to combine or reconfigure the parcels.
In reference to 844.
Right. Okay, so I move to accept the findings of fact, acknowledging the characteristics of the property as laid out in the correspondence reference to this case. So I move to accept the findings of fact in the interest of granting the minimum lot size requirement variance request. Do we have a second?
Seconded.
Okay, so we have a motion to accept the findings of fact for VAR 25-068, Robert C. Burns, 844 Riverview Drive. We have a second. How do we vote?
Aye.
Aye. Aye. So, that being said, I move to grant the variance request with regard to satisfying the minimum lot size requirement. Do we have a second for that?
I'll second that.
Okay, so we have a motion to grant the variance requested for VAR 25-068, seconded by Mr. DeWitt. How do we vote?
Aye.
Aye. Aye. Okay, so we've granted the variance requested specifically for 844 Riverview Drive. We're moving to, so you will receive written notification with regard to this specific case, 7 to 10 business days. It can go before Circuit Court of Montague County. Anything you do in that 30-day appeals window, you do at your sole financial risk. We are moving to, it's a very similar case, VAR 25-073, Camille Caruso Weiss, 844 Riverview Drive, request by Camille Caruso Weiss for variance relief from section 1333.03 of the city's planning and zoning code regarding minimum lot provisions, City Tax District 15, 4th Ward, Tax Map 015 in Parcel 20, R1, Single Family Residential District.
As is with the previous cases, here is a top-down kind of view of the parcel in reference, being 888, as well as that buffer zone. And then the same plat as previously mentioned, showing the cutout from what was previously a part of that parcel, and showing what the parcel would look like now, being this on the right. The applicant wishes to combine a portion of their lot with a neighboring lot at the reference address. 844's Riverview's driveway is on and accessed through 888 Riverview for a period of time through a civil agreement. They are now interested in changing the parcel, so an agreement is no longer necessary, and it would just be by right. This change would add lot size to 844 while decreasing the lot size of 888. Refer to the relevant sections of code below. In summary, the applicant wishes to combine neighboring lots with structures on them. The applicant is requesting variance regarding 104 square feet of minimum lot size. Please see the attached applicant's application to review the findings of fact listed. As staff have had no comments or modifications, staff have no objections to the applicant's request for variance relief. If the Board of Zoning Appeals grants the applicant variance relief from Section 1333.03 of the city's Planning and Zoning Code, this new lot shall be subject to the following conditions, being that standard one that I've referenced previously.
All righty. Anything to add with regard to this specific case? At that different address, 888 Riverview Drive. All right, nothing further to add from the representative from the last case, so we're going to open the public hearing for this specific case, 888 Riverview Drive. Anyone wishing to speak in support of and opposition to this case, please do so now. Going once, going twice. We're going to close the public hearing. Thank you. All right, so very similar case. I'm going to make a motion to accept the findings of fact.
Second that.
With regard to that, especially with regard to that correspondence,
Yeah.
which bears on this case as well. We have a motion to accept findings of fact. Do we have a second?
I'll second that.
We have a motion to accept findings of fact, seconded by Mr. DeWitt. How do we vote?
Aye.
Aye? Aye. And then it's pretty straightforward. Findings of fact bearing on that correspondence, very similar case. I move that we grant the variance request for VAR 25-073, 888 Riverview Drive.
Seconded.
And we have a second by Mr. Misfelt. How do we vote?
Aye.
Aye? Aye. Okay, so that case, or that specific variance has also been granted. Again, written notification for this separate case from planning, 7 to 10 business days. It can be appealed to the Circuit Court of Montague Counties, so please keep that in mind. Any work that you undertake in that 30-day appeals window, you do at your sole financial risk. Thank you very much.
Thank you.
You're very welcome.
You will give these to Ricky when you send them to me?
Oh,
These
yeah.
are for planning.
Yep.
This is a condition of
Mhm.
the final approval.
He'll get it in there. Yep.
You know, if you can make me read the plan, 6 weeks.
Well, I'll do what I can.
Thank you.
Thank you. Have a good evening. Do we have announcements?
No, other than, they talked about previously, but Barb McDonald is no longer working with the
Right.
city, so, correspondence or anything like that, don't send it to that email, at least for the time being. Just bother me or Ricky, preferably me if you could,
Ricky
related to
sent out the
that.
last announcement, and is he going to be continuing to do that, or is that going to be something you do? or-
It'll probably be me going forward, if you happen to see it from Ricky, but at least for, if you can attend, or expectations of receiving something, it'll be from me.
I was just reply,
Same.
Yeah.
just
yeah.
to make sure that it goes to whoever originates
I
it.
haven't done the reply all. 'cause
I don't do that. I used to, but I
But otherwise, no other announcements of that nature.
There are cases that
There will be
are coming.
cases for next
I'm
month.
sure. Oh, yeah.
Yeah, we have a few, so look forward to it, I suppose, but otherwise, that's it for staff.
All right. So I move to adjourn,
Seconded.
and thank you, everyone. Have a good evening.